Good. Hey, welcome back, and welcome back to the series on how you can sue a law enforcement officer who violates your civil rights, part two of two. You got to forgive me the last part of this series, people. I applied a lot of my personal experience to it to try to make it a little more applicable for the people who are watching. However, that may not have been the case because I noticed that the broadcast extended far past the time that I wished for it to. I only planned on doing this in about a three-part series. So today I'm going to cut all of that out. And what I'm strictly going to do is I'm going to read from my cue cards and I'm just going to go through the cue cards to see how much of this we can get through today. Um, and if we need to further define into anything, you can drop comments, you can leave notes in the comments, you can contact me and we'll try to go a little further, or I'll even email you this document so you can review it yourself. Okay, so let's get into it. Okay, so we are going to start where we left off. We'll do a quick review. So, Section 1942, United States Code, Section 1983, excuse me, 42, United States Code, Section 1983, excuse me. And it reads something like this: every person who, under color of any statute, ordinance, regulation, custom, or usage, or any state or territory or district of Columbia, subjects or causes to be subjected any citizen or of the United States, excuse me, or other person within the jurisdiction thereof to the deprivation of any rights, privileges, or immunities secured by the Constitution and laws shall be liable to the party injured in an action at law, suit in equity, or otherwise properly proceeding, or other proper proceeding for redress. So we did speak about what that means with regard to the immunities, the constitutional obligations of the government towards you, how that has been established through case law. We briefly went through that. The next thing we talked about, excuse me, was establishing a claim under 1983. And how did we do that? So we broke that down briefly in this third slide, excuse me, that it does not create a right in itself. The only thing it does is give you a way to go after the people who work in the government who may have denied you a right that you are entitled to. It does not create a right in itself. It just gives you a way to obtain a right that you were denied by people who work for the government. And that could be anything. It could be on a criminal, a civil level. It could be on a judicial level. It could be from the DMV, something they may do to violate your rights with regard to your license, discriminating against you. The application to this statute is immense. So I'm only speaking about it in terms of family court and criminal justice, but it's applicable across any government office. Excuse me. To establish a claim, the plaintiff must demonstrate a violation of a right occurred, a right secured by the Constitution and the laws of the United States, and that alleged deprivation was committed by a person acting under color of law. Basically, what I just said, that you were denied a right, and the person who denied you that right just so happened to be a person who works for the government. All right, so let's keep going. See, we'll go to the fourth slide. That the history of Section 1983. The history of Section 1983, again, ladies and gentlemen, is it was enacted. It originates, excuse me, from the April 20th Civil Rights Act of 1871, which was ordered by President Grant to combat the Ku Klux Klan, which was conveniently disbanded 3 years before this act was ever even created. It was never actually used to prosecute members of the Ku Klux Klan, excuse me, because by the time it came into effect, the Ku Klux Klan had allegedly been disbanded. Um, I talked about a little bit how a number of the cases in the 1970s, 1971, I believe it was, Pope versus Monroe actually was the first case where law enforcement established that this statute could be used to hold law enforcement accountable for violating your rights. And that's Pope versus Tate, and I believe it was in 1971. If you check the notes in my bio, you will see that case referenced. All right, let's go to number four. Excuse me. According to the third jury instructions, plaintiffs again have to establish two aspects of a 1983, which is that the defendant, the person you're suing, was a state employee or had the protections or the position of a state job, and two, while they were employed in that state job, whatever they did deprived you of a right you are secured by state or federal law. That's the only two-pronged system to establish a claim under 1983. If you can establish that, then you have a claim under 1983. Let's go forward to slide number 6. Every person, that means private citizen, myself, You guys, as long as you are a citizen of this country, you are entitled to a balancing of your rights under Section 1983 if someone who is working for a state or federal agency or city agency violates your civil rights, or a city ordinance, a city statute, a state immunity, whatever it might be. If it is a law guaranteed to you by some state or federal statute, or or constitutional law, then you are entitled to an action under 1983. Now, it has to be a person. And what that means is it has to be a physical person, like a district attorney, like a cop, like a social worker, a DCS worker, a health department official, someone who works for a government department. It cannot actually be the state of New York, because for purposes of 1983, a state is not actually a person. And that was by design by the members of the Congress of 1871. They didn't want private litigants to be able to sue the state and be able to obtain things like the courthouse, or the federal building, something like that. Because if someone sued the court for a state enough in a jury trial and received a large verdict that a municipality couldn't pay, then in effect, the person would end up owning the courthouse. So to stop that, what the 1871 Congress did was remove the ability of a private citizen to sue a state. If you want to do if you want to sue a state, you have to do something called a Monell claim, which happened, I believe, in like 1970 something, where a bunch of pregnant women sued the Board of Education for rights with maternity leave, something to that effect. But let's keep going. Number 7, who is under color of law? The traditional definition, as I told you, under color of law is any person who is acting under the color of the law with a job for the state, city, or federal government. That's the easiest way to describe that. Such actions, when they violate you, if they're acting while in their government job or using their government capacity, that is something that makes them liable to you for damages. You can't get them arrested, so don't try for that. I wouldn't try. It's not about going to get them fired. It's not about that. The only thing you're going to be able to do is get some type of relief. Well, you can get a declaratory order, where you can just basically order that what they did violate your civil rights, and the court will issue you an order that going forth. Or you could receive monetary damages if you lost things like your income was hurt. Let's say your reputation was damaged. Let's say you lost your liberty. Your First Amendment rights were violated, whatever it might be. You can receive a monetary damage if they do something like that, but you're never going to get them criminally arrested. So for those of you out there who say, I'm going to sue the police, he's going to jail, don't kid yourself. The only way people go to jail is when the cops get involved, and the cops prosecute who they want to prosecute, not who they're supposed to, who they want to. All right. Let's go forward to number 8. Okay, who under color? Nope, that's not it. Let's go forward to number 8. Come on. Any person in the cause. State law means any statute, ordinance, regulation, custom, or usage of any state. This includes any political subdivisions of the state, such as a county or municipality, as I told you. So anything that you are granted by a state, city, or the federal government, to which an employee of that state, city, or federal government deprives you of, you are entitled to a claim under 1983. 1983 attaches only to those wrongdoers who carry the badge of authority of the state and represent it in some capacity, whether they act in accordance with their authority or misuse it. So basically, if they're trying to act in accordance with their authority, where they're claiming that their actions were something that was correct and they're not wrong, or either if they intended to do it, either way, if you were damaged in any way, they are liable, whether they intended to do it or whether they didn't do it. The only thing you have to establish is that whatever they did violated your right. All right, let's go on to number 9, people. We're going faster than we went last time, so that's good. Come on, 9. Come on. There we go. All right, so we talked about the elements of 1983 under color of law. The injury to the question of Section 19, the inquiry into the question of action under 1983 is fact specific. In the casual case, courts ask whether the state provided a mantle of authority that enhanced the power of the harm-coming person. So basically what they mean by that is if the person's job enhanced their ability to deprive you of a right that you were granted. In essence, if a cop uses their authority to set you up, yes, his job did enhance him with the authority to set you up. If a district attorney uses their position to withhold evidence that could have either substantiated your claims or disprove the claims of another. Yes, they used their position, the fact that they had this secure position to introduce evidence, to withhold or introduce negative evidence that could have hurt the truthfulness of the aspect of what's going on. So basically, that's all that's saying. The Third Circuit has found such circumstances to include. Okay, I don't think that really matters. Da da da. Let's keep going. Da 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 da. Again, it can be used as a remedy for the deprivation of rights, meaning they're withholding a right from you. It doesn't create a right in itself. A good example of that is, let's say hypothetically, it's illegal to cross the street before you count to five, and you sue them because you say you crossed the street before you counted to five. It's not going to grant you the right to cross the street before you get to four. No, you have to stick to it. If they violate your rights because you crossed the street before five, they're not going to give you a play hypothetically if you made it to six. You still broke the law regardless of the circumstances of it. It has to be something that you are entitled to. If it's something you're not entitled to, they're not guilty of violating any federal or constitutional right. Okay, let's see. We can go past that one. Okay, I think we pretty much summed up Maine versus Tibbet. We talked about these. We talked about the three-pronged test for finding the right enforceable under Section 1983, which was set forth in the case of Wilder versus the Virginia Hospital Association. It asked whether, one, Congress intended the particular statutory provision to benefit the punitive plaintiff, whether or not Congress enacted the right that you are claiming that you were deprived of, whether or not Congress enacted it for the specific purpose of granting you a right or protecting you. That's one. Two, whether the provision is not so vague or amorphous as to make a judicial enforcement difficult or impractical. Basically whether the statute was clear enough to establish that if someone does something wrong, there's a clear action to what's going to happen. They don't want you to try to interpret something where they're going to have to try to dig through it to figure out what it means. It has to be a clear violation of something that you're supposed to have. Let's say it's immunity against prosecution. Excuse me. Let's say it's your rights with respect to the First Amendment. Let's say it's your rights with respect to your Fourth Amendment rights against search and seizure. Let's say it's your Fifth Amendment right to a due process, something to that effect. It has to be an established right you have. And I think I've already said that a couple of times. So I think now we are getting to a new topic. Let's talk about something called a class-based animus. Now, class-based animus refers to a discriminatory intent or hostility directed towards a person or group based on their membership in a particular class. Basically, what that means, a class-based animus, is if a person doesn't like you because you're black, or a person doesn't like you because you're gay, or a person doesn't like you because you happen to be a woman, or a person doesn't like you, because you happen to be an Indian midget. Anything that would make you a minority class or a protected class that a person doesn't like you for and uses that to violate your right creates what's called a class-based animus. Now, this concept is often discussed in relation to claims under Section 1985, which is the conspiracy to interfere with the civil rights of someone else. Now, this came into effect mainly in the 1871 Congress because the Congress realized that state actors or state employees were using personal connections as far as having witnesses lie under oath to get people out of committing crimes against African Americans, working over juries, buying juries, manipulating juries to make a bunch of people that would be favorable to a defendant who violated someone's criminal rights, things of that nature. So in I guess examining that, Congress realized that, okay, wait a minute, these people are manipulating the judicial process to create conspiracies to deprive people who are supposed to have rights without rights. So with respect to that, I believe part of the 1871 bill was amended to become Section 1985, which is the conspiracy to interfere with the civil rights of someone else, or the conspiracy statute. I won't talk about my situation in relation to that. I'll move forward. I was about to. Okay, class-based amnesty is continued. Civil action for deprivation of rights for a rights action involves discriminatory intent against a protected class, which is a critical element for claims under related statutes like Section 1985, which is what I just said. In the context of Section 1985, while the statute itself does not explicitly require proof of invidiously discriminatory animus, Such amnesties can be relevant in establishing the discriminatory intent behind the actions that violate constitutional rights. Basically, what that means is you can establish that this person's actions were motivated by the specific class you represent. You got them. That's what that means in the simplest of terms. For instance, classes where plaintiffs allege violations for equal protection under the 14th Amendment, demonstrating invidiously discriminatory amnesties, can be crucial to proving that the actions were not merely arbitrary, but were motivated by harmful discriminatory intent. Now, what does that mean? Under the 14th American, as an African American, I am entitled to the same protection that a white man is entitled to. If I go to the police and the police decide not to investigate a crime that I tell them because I happen to be an African American male, even though they would investigate this crime for a white gentleman, who came in and reported at the same time, that would create a class-based amnesty. And in the creation of that of that discriminatory motive would basically establish the discriminatory intent of why they were doing it. We're going to move forward because we're going to make it through this today. We're going to get this done in 40 minutes. All right, class-based amnesties continue. In the case of Howe versus Doyle, the court noted that a Section 1985, Section 3 claim requires showing a conspiracy motivated by a class-based invidious discriminatory amnesty. Like I said, in order to meet the criteria for 42 United States Code 1985, subsection 3 claim, you have to establish in some way that you, because you are a protected class, were discriminated against because of the status of you being oh God, why can't I think of this word right now? I'm tongue tripping right now. Of you being connected to the same class of person or the same class to which they're discriminated against. You have to prove to the court that for some reason this person has had a reason to discriminate against you. And people, it's not as hard as you actually think, because most of the time law enforcement does discriminate against you. It could be because you're a male, it could be because you're a woman, it could be because you're black, it could be because you're Indian, it could be because a white man looks at another white man and judges that white man as poor white trash. Poor white trash, believe it or not, that is a subclass also that can establish themselves as a class-based amnesty in a civil suit using a 1983 claim. Poor white trash people, or at least white people that are interpreted as poor white trash, are discriminated against all the time. Discrimination is something that affects the lives of not only black men like myself, it affects many different nationalities of people, even white people to an extent nowadays, surprisingly, what I've learned in the last couple of weeks. But not to sidetrack too much, let's keep going. Similarly, in Mandawala, versus Northeast Baptist Hospital, the court emphasized that both Section 1985 and 1986 require proof of some racial or perhaps otherwise class-based invidiously discriminatory amnesty. Again, for Section 1985 and 1986, which we haven't really talked about much yet, you have to establish the fact that in some way, whether it be racial or sex-based or class-based, in some form you were discriminated against. That is the major criteria of establishing any of these 1983, 1985, and 1986 claims, is you have to establish the fact that, actually 1983, you don't actually have to establish the fact that you were, I believe, racially discriminated against. I could be wrong, but I'll look into that a little more. I know you have to for 1985 and 1986. Let's go forward to slide 16. All right. Invidiously discriminatory amnesty. In the context of civil rights in 1983, civil action for the deprivation of rights refers to a type of discriminatory intent that is particularly harmful and unjust. Of course, I think everybody got what that meant. The term is often used in cases involving, again, Section 1985, conspiracy to interfere with the civil rights, which requires that the conspiracy be motivated. Okay, I read that already. We can keep going. 17. Elements of a Section 1983 claim. Section 1983 does not impose a state of mind requirement dependent of the underlying basis for liability, but there must be a causal connection between the defendant's actions and the harm that results. So basically, like I said earlier, with a 1983 claim, you do not have to establish the fact that you don't have to establish the fact that the person intentionally violated your right. The only thing you have to establish the fact is that this person who had a state, city, or government job did something wrong, and what they did violated your rights protected under state or federal law. That's it. The U.S. Supreme Court has interpreted this causation Element to require that the harm be the result of action on the part of the government entity that is implemented or executed a policy, statement, ordinance, regulation, or decision officially adopted or promulgated by the body's officers or the result of the entity's custom. Monell versus the Department of Social Services. Now, I'm not going to get into that one too much because I'm actually going to do a whole video on Monell versus the Department of Social Services, because that's how you sue a city or you sue a state municipality. You can't file a 1983 if you, let's say, you want to sue the city of New York, because the city of New York is a municipality and it's not subject to respondent superior, which is a major component of 1983. So you have to use what's called the Monell claim, and that's a whole nother video. So we'll do that later. The Supreme Court has rejected the notion that a plaintiff must meet a highlighted pleading standard to state a claim against a municipality for an unconstitutional custom or violation. So you don't have to meet a higher claim to establish the fact that a municipality, let's say the city of New York, violated your rights. You merely have to establish it using the Monell doctrine, which we'll have another video about. We'll talk about that again later. Let's go forward. We're doing pretty good today, guys. We're at 20 minutes. Elements of a Section 1983 claim. Any person to the deprivation of rights. Section 1983 is not itself a source for substantive rights. Again, it doesn't grant you. You won't be granted a right through filing a lawsuit using 1983. They'll only correct the fact that a right was deprived from you in 1983. You're not going to get something new. They're just going to give you something, or they're going to correct something that was done to you wrong. And I have to clarify that so people don't think it's just a way that you can get something done. That you can't get something done wrong unless you can prove that it was something constitutionally or state order or state granted that was violated to you, period. All right. Therefore, a plaintiff must prevail only if he can demonstrate that he was deprived of rights secured by the United States Constitution or federal statutes. I said that. The 14th Amendment's due process clause is the most commonly invoked substantive right. Like I told you, the 14th Amendment grants you certain rights as a private citizen that law enforcement is inherently known for depriving private citizens of. What they do is they use the cloak of 11th Amendment immunity to try to tell us that we don't have the rights to complain against them. And people, what I'm trying to teach you is by using Section 1983 in Monell versus the Department of Social Services, which we'll do another day, you can hold these bastards accountable, because people, a lot of them are bad. Not saying all of them are bad. Law enforcement's job is to protect society and help us. But when they turn against us, when they work against us, when they do things to deprive us of the liberty and the freedom that they are supposed to help us maintain, then we have to find a way to hold them accountable. Otherwise, we're going to constantly just be cogs in the systems, an unwilling participant in a sick game to keep lifestyles of other people consistent. I don't know about you guys, but I don't want to keep going to jail just so a cop can pay for his boat or pay for his car payment or pay for his kid to go to college. He better figure out another way and put a hustle hat on. He ain't going to get it off of me. Let's keep going, people. Shall be liable in an action at law, suit in equity, or other proper proceedings. So this is just a breakdown of the end part of Section 1983 that states exactly what will happen if you can prove that someone who has a government, state, or city job violates your right while they're on the job, something you were entitled, that they shall be liable in an action at law, suit in equity, or other proper proceeding. There is no requirement that the plaintiff sue in federal court because state courts have concurrent jurisdiction, meaning on a state level, you can use 1983. It doesn't have to go to federal court. State courts allow you to file Section 1983's claims under the state law. But most of the time, when you sue the police or you sue a state prosecutor, they're going to try to move you to federal court using what's called the federal question, which is that you're questioning the fact that they violated your federal rights under the Constitution. So they're going to file, I forgot what title it is again on the application, but they're basically going to try to have you removed from state court to federal court because the federal court may grant them more protection as prosecutors with the 11th Amendment community clause. But people, as long as you have a valid claim, you don't really have to worry, because if they violated your civil rights, no amount of maneuvering is going to stop the fact that happened. Again, true, law enforcement does have immunity, but when they violate your rights, they can be held accountable. You just have to have enough discipline to be in for the long haul, because it's not going to be a short process, and you damn sure got to be willing to work to gain the knowledge to do it. Otherwise, you will never, ever receive justice. They will purposely work against you to deny you the justice that you deserve. And it does not matter how many times your rights are violated. They don't care. If they don't like you, they'll continue to violate your civil rights. What I'm trying to teach you is to put before them a way to stop them, to hold them accountable, because maybe if enough of them us can hold them accountable, guess what will happen? They'll stop. So let's continue. Okay, let's move on to 20. All right, states and state agencies are entitled to 11th Amendment immunity, which is what I just said. The state and regional legislators are absolute immune as long as they are engaged in traditional legislative function. Local legislators, such as city council members and council and county commissioners, have been granted absolute immunity also. See, people, so as long as they're doing what's right, what's in their job, even if something happens that's wrong, for the most part, they have absolute immunity, which means it's nothing you can do. They have to really, 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 really do some shit, if you understand what I'm saying, in order for you to get them. So they're the harder. Absolute immunity is the harder of the two, because what you have is absolute immunity and you have qualified immunity. And qualified immunity is the lesser of the two. Um, Individual capacity defendants are protected by qualified immunity. I just said that. Government officials are entitled to qualified immunity unless their act is so obviously wrong in the light of pre-existing law that only a plainly incompetent officer or one who is knowingly violating the law would have done a thing wrong, like I'm saying. So when a cop falsifies a report against you, if he manipulates a complaint to make it more presentable to have you arrested, if a district attorney creates a legal document or does a filing or pretends like they file an evidentiary submission motion that never happened, people, these are all things that violate your civil rights. And it's things that the cops are supposed to know better than, because what happens when they get the job? They receive training. The training teaches them how to do the job. So the training does not teach a cop to falsify a complaint against a criminal defendant. The academy doesn't teach you that. The cop learns that in the course of his job, trying to make arrests just to make himself seem like he's doing his job to get whatever promotion or salary increase he wants. Same thing with a district attorney. A district attorney who withholds evidence and receives a conviction is just trying to get that conviction because they realize that the conviction is going to raise the bar to which they want for their career. So they're willing to sacrifice the freedom, the life, the liberties of someone else to advance their career. And they may withhold evidence. They may falsify evidence just to violate someone's rights. People, all of this is something that they would willingly know is wrong, but they do it anyway. And by such, they would be liable under a 1983. Let's keep going. We're doing good, people. An individual defendant in federal court may immediately appeal a denial of qualified immunity, even if a prior appeal of a denial of qualified immunity was unsuccessful, and even if other claims remain for trial. So people, what that's telling you is that even if they try to claim qualified or absolute immunity and you are able to effectively argue this to a court, and the court denies their dismissal, which is a 12B motion, they file what's called a motion using Federal Rule of Civil Procedure 12B, which basically states that if you can put a pre-existing issue before the court that protects a defendant, you can ask for a dismissal before you get into any proceedings. And this is the common tactic used by law enforcement, cops, and district attorneys, so that they don't even have to get what's called the evidentiary or the disposition phase, so that the court may become more aware of the things that they have done, because they don't even want to get into court to let a jury or a court hear some of the things that happen. Because once a good federal judge, an honest federal judge, starts to hear some of the things that some prosecutors do, they realize they have a problem. So what they'll do before you ever get into the disposition phase, the discovery phase, or like I said, disposition, is they'll try to get it dismissed using a Federal Rule of Civil Procedure 12B. Private individuals who perform state functions and private corporations who contract with the government may be entitled to qualified immunity. So what that basically says is independent contractors, people who have government contractors, as long as they're acting with the government's authority, they may be entitled to qualified immunity also. Real simple, but I don't think that applies to us here. Well, it kind of could if you use like a social worker or something like that. Let's say you have a social worker that's working with you, privately contracted by family court, that violates your civil rights. Technically speaking, they may be protected by qualified immunity, but it kind of depends on the extent of the damage they do, if you understand what I'm saying. All right, absolute and qualified immunity defenses. Let's go. The Supreme Court has also recognized a qualified immunity defense to Section 1983 actions in certain circumstances. Most state and local officials and employees who do not enjoy absolute immunity are entitled to qualified immunity. Thus, a prosecuting attorney who enjoys absolute immunity in performing her prosecutorial function may also enjoy qualified immunity in hiring and firing subordinates. The Supreme Court has held that the school board members, state mental institution administrators, law enforcement officers, prison official, state and local executive has qualified immunity. People, pretty much all of what I just said to you. While prison guards employed by the government, local, state, or federal, are covered under qualified immunities, guards who work in for-profit prisons engagements are not. So people who are in private prisons, technically, if the prison is owned by a private corporation and the guards are private securities, they are not entitled to any type of immunities. But the way the government sets up the private industry, people, how the hell can we know nowadays? From the last time I checked, BlackRock owns most of the prisons in this country. But we're never going to know because they're in partnerships with the state that's so well that technically the state still on its surface appears to own the prison system. But let's go forward because I don't even want to get into that right now. All right, we're on 23 and we're at 30 minutes. We might actually finish this. The plaintiff bears the burden of proof on all elements of a Section 1983 claim, which basically means it's your responsibility to prove every word that you said in that claim or complaint against that government or state official is true. Although the defendant has the burden of pleading the defense of qualified immunity, the Supreme Court has not definitively established who bears the burden of proof with respect to the defense. So you're allowed to defend it, but they haven't established to the extent I would say who bears if the plaintiff or the defendant bears the burden of proof to prove if this person is entitled to qualified immunity. And I assume they do that just because they want to give someone the right to adequately argue both sides of whether or not you have immunity and whether or not you don't. The Third Circuit has stated that the defendant bears the burden of proof on qualified immunity. I just said that again. People. It's amazing, though. Sometimes things happen to you so bad, they do make you better people. So you have to be grateful. Okay, I think I just skipped one. I think I'm bugging out, people. Yes, I did. The Supreme Court has held that Section 1983 creates a species of tort liability. A Section 1983 plaintiff is also required to prove that a federal right was violated, and similar to tort law, that an alleged violation was a proximate or legal cause of the damage that the plaintiff has suffered. So basically, you have to prove, like I have said, that in some way your civil rights were violated, and because they violated your civil right, it harms you in some effect. There has to be a cause and an effect, period. The plaintiff punitive damages are also available under Section 1983. We'll talk about punitive damages on another broadcast. A plaintiff is entitled to punitive damages if the jury finds that the defendant's conduct was reckless or callous, indifferent to the federally protected rights of others, or if the defendant was motivated by an evil intent. The jury has the duty to assess the amount of punitive damages because the purpose of punitive damages is to punish the wrongdoer. Such damage may be awarded even if the plaintiff cannot show actual damage. What that means, again, people, is that punitive damages is the damages that they award a plaintiff, and I wasn't going to discuss it, but I forgot I put it in the slide, so I might as well. You are awarded punitive damages once you can prove someone damaged you to the point that you are entitled to damages. And the purpose behind punitive damages is not for you to set the amount. It's for an amount to be awarded to you sufficient enough to hold the wrongdoer accountable for what they have done. This is why people get $10-20 million lawsuits, because a jury or a judge decides, mostly a jury. Most of the time when people get really large settlements, it comes from juries. So a jury has decided that someone is liable to this person in excess of 30, 40, or $50 million. That's why you see that happening. All right, let's go forward to 25. Section 1983 provides a remedy for the violation of federally protected rights by government and its employees. We said that. Civil litigants were still precluded from suing government entities themselves until 1978, when the Supreme Court decided, like I said, people, damn, I've been studying this a lot, Monell versus the New York Department of Social Services, which was basically this woman, don't remember her first name, Monell. She was pregnant. They were making women take early maternity leave. So this whole big case enacted by these women by the Department of Social Services because of the maternity leave. I believe I'm correct, but I think that's what Monell versus the Department of Social Services was about. All right, let's keep going. In Monell, the Supreme Court held that that governments could be persons under the language of 1983, but that such liability could not be based on the respondent superior basis. Now, people, again, I am an amateur lawyer. I haven't fully grasped the concept of respondent superior, so I'm not going to explain it to you. I'm going to ask that you look more into it. But as I become more knowledgeable, you'll become more knowledgeable. So it's all good. Let's keep going. Let's see, city what is the city of Can? What the heck is that? Oh my God, people! I'm sorry, my thing is cutting me off and I can't see, which really sucks. But oh, that sucks. All right, let's go back. City of, I think that's Canton versus Harris. One of Harris's theories of liability was that the city of Canton had failed to adequately train its officers about providing medical assistance before emergency first treatment. Okay, I remember. So this is a breakdown of a case that I read, which is the city of Canton versus a gentleman of the last name Harris. This is a Monell claim, which I'll read again. One of his theories of liability was that the city of Canton had failed to adequately train its officers about providing medical assistance beyond emergency first aid treatment. He sued the city. He sued the city of Canton because he was in an accident, and the city of Canton's officers failed to provide him first aid treatment because they didn't feel he was injured seriously enough. He felt that the city should have provided these officers with training that mandated them to provide medical assistance regardless of the fact that someone required immediate first aid. The circuit court had held that the government could be liable for a failure to train when it acted recklessly, intentionally, or with gross negligence. The Supreme Court granted cert to consider the applicable standard for providing liability based on failure to train theory. So there's a theory that they use, failure to train, which is basically they say that these state actors, cops, law enforcement officers, because the city themselves or the police department themselves failed to claim them, because I forgot to mention you can also put a Monell claim against the police department. You can put a Monell claim against the family court. You can directly sue the family court. You can directly sue a family court judge using Monell versus the Department of Social Services, because a family court judge is not a person considered under the Respondent Superior Doctrine of 1983. Neither is the family court, because remember, the family court is a building, it's an entity. Under 1983, a building or an entity is not considered a person or respondent superior. So what you have to do is use the doctrine of Monell versus the Department of Social Services to hold that entity that the 1983 doesn't consider a person, Monell versus Department of Social Services does. So you have to incorporate the two in order to make the overall concept of it work. The Supreme Court, I read that one, so we got to keep going. All right, people, we're almost done. All right, City of Canton versus Harris. The Supreme Court first cited its reasoning for Monell that it is only when the execution of the government's policy or custom inflicts the injury that the municipality could have held under 19 inflicts the injury that a municipality can be held under 1983. So I'm going to read that again because I'm getting tired, so I'm stuttering a little bit, people. It is only when the execution of the government's policy or custom inflicts the injury that a municipality can be held liable under 1983. So what that means, people, is let's say the cops do have a habit of ignoring male victims of domestic violence. People, that's an established custom or practice, as they don't take male victims of domestic violence as serious as female victims. So using Monell versus the Department of Social Services, let's say, you could sue the police department for a failure to protect and enforce the rights granted to victims of domestic violence, but if they fail to protect a male victim the same way they fail to protect a female victim. The Supreme Court acknowledged that there are limited circumstances when an allegation of failure to train can be a basis of a 1983 claim. Like I said, those limited circumstances are something like I just said, when you can establish that the police failed to provide equal detection to Black men or to Hispanic men or to gay and lesbians who may live in a building, who may report noise violations to the cops. The cops might not take them seriously. You can all of these situations are situations to which you can use Monell versus the Department of Social Services to hold the municipality or the police responsible for violating your civil rights, not using the Respondent Superior Doctrine of 1983, but rather incorporating it into 1983 using Monell versus the Department of Social Services. I hope that makes sense. The Supreme Court also held that the inadequacy of police training may serve as a basis for 1983 liability, only when the failure to train can amount to a deliberate indifference to the rights of persons with whom the police come in contact. People, I just said that to you, but it was said a lot more intelligently there. Basically, the police, if you can prove that the police are inadequate in protecting you because again, I apply it to myself. You're an African American male. That enough is to serve for the basis or the grounds of your 1983 claim. Because what you can allege is that the police department or the city of New York has not provided adequate training to its officers to what's the word I'm looking for, people, to recognize and act on male victims or African American victims of crime or domestic violence. So that would give you a claim under 1983 and the Monell Doctrine to go after this municipality. Okay, let's go. We got 2 slides left, people. We're almost out of here. All right, the city of Canton versus Harris. The court held that a municipality may be held liable under Section 1983 for violation of rights guaranteed by federal constitution, which excuse me, which violations result from the municipality's failure to adequately train its employees. Only if the failure results in deliberate indifference on the part of the municipality to the constitutional rights of the inhabitants. I've kind of gone over that a few times, people, and we're not going to keep going. The court was concerned that allowing a lesser culpability standard than deliberate indifference would result in a de facto vicarious liability, and was further concerned that the federal courts should not be in the business of second guessing employee training programs. So that means they put some criteria on it. They don't make this easy. That's basically what that means, people. I'm not going to further explain something that's kind of obvious. They're not going to make it easy for you, but if you can flat out prove that someone who worked in one of these offices, or that the police department is violating you, or that the local department of social services or the court, or you can prove that the court has a habit, let's say, of unjustly prosecuting a certain sector of society or a certain subclass, then that's the grounds for a Monell claim. Harris makes clear that the viability of a failure to train claim must contain sufficient evidence of the following facts. So in order to establish a failure to train claim under Monell versus the Department of Services, this Harris versus Canton case has established some clear facts that you should keep in mind if this is something you want to talk to an attorney about. 1, a violation of a federally protected right, a violation of your constitutional right, Bill of Rights, whatever it may be. Some federally protected right you have, you can automatically prove it was violated, whether it was your right to be free of illegal search and seizure, false arrest, your right to due process in the court if you're falsely arrested, or if you're on trial for something, let's say a prosecutor withholds information, or your simple basic right to freedom of speech, or your 14th Amendment right to equal protection under law. 2, inadequate training of its employees. Basically, you're establishing that these employees do it can't be one employee. It has to be several employees within a set organization that follow a specific practice, and the practice doesn't have to be on paper. But basically, if you can establish that if you can create enough probable cause to allow a reasonably sufficient judge to understand, something, this person is making claims and they're being ignored, but this same person makes claims of a lesser degree and they're prosecuted to the maximum extent, then you can establish some sort of discrimination that may make a court, prosecutor, judge liable under Monell versus Department of Social Services. All right, let's keep going. Courts have recognized that Section 1983 training liability can arise in 2 potential scenarios. 1, where a series of constitutional violations makes the need for training obvious. Such a pattern of constitutional violations is typically necessary to demonstrate that a government entity was deliberately indifferent to its citizens' constitution's rights. People, again, like when the police failed to protect Black people who were constantly being assaulted by racists in the South. A lot of this happened because of the racism in the South between the 60s and the 70s and even early 80s. A lot of the Monell and the 1983 claims, believe it or not, people. In 1983, liability can also arise in the absence of a pattern of violations where the need for training on a particular issue was obvious on the start. This is why a lot of police stations and police organizations, have instituted racial training programs, even district attorneys' offices, because the truth of the matter is they can no longer ignore a problem that is obvious to society, that some people do slip through the cracks. A lot of people slip through the cracks, and they have biased opinions that are unfavorable towards certain classes of people. And this is why now you have offices like, let's say, hypothetically, the Manhattan DA, the LAPD, they have programs and training to provide was it I forgot what it's called. It's like some type of racial training. I can't remember, racial sensitivity training or something like that, to teach people how to interact with other classes of people, to deal with the department's own liability and its officers discriminating against the protected classes of people. Excuse me. And we're on the last slide, people. So, Connick, excuse me, in Connick versus Thompson, the Supreme Court recently tightened liability standards for Section 1983 claims involving alleged failure to train government employees. In Connick, the Supreme Court reversed a $14 million award to a plaintiff and former prisoner. The Supreme Court rejected the former prisoner's claim in Connick because it did not, within the narrow range of hypnotized single incident liability concerning where the need for training was obvious on the onset. The court noted that the armed police must make split-second decisions with life or death consequences, whereas prosecutors have legal training and take continuing legal education. The court held that one, prior unrelated Brady violations by attorneys in his office was insufficient to put the district attorney on notice to the need for further training. Two, the need for training was not so obvious that the district attorney's office was not liable under failure to train theory, where non-disclosure of blood test evidence had resulted in defendant's wrongful conviction and in his spending 18 years in prison. So from that case, they tightened the constraints of a 1983 claim because they basically said that because the DA withheld evidence, which is a Brady violation, that this guy was not entitled to damages because even though and I just lost that part. Forgive me, people. I got tired. I've had a long day. Okay, so the police, they couldn't be liable for failure to train because they didn't expose blood test evidence that resulted in a wrongful conviction. I don't even understand that one, people, but I'm kind of tired. And I did read this case. I just don't remember. So people, for the most part, and conclusively, we have discussed my interpretation of a 42 United States Code 1983 claim, what it's about, how you can establish it, what the elements are. We talked about what the history is, We talked about what the elements are. We talked about how you can establish a claim. We talked about how you as a plaintiff, what color of law is. We also talked about how someone is acting under color of law. We talked about what you can actually receive, what you are actually legally able to ask for in damages, whether they be punitive, declaratory, etc. We talked about some relevant case law. We talked a little bit about Monell versus the Department of Social Services and how you can effectively sue state or the police for failure to train. We talked about a lot in this broadcast. For those of you who like, share, and follow, forgive me because I'm going to get off. I am very tired. And I hope this was informative. The next broadcast we'll come back with is we're going to discuss Monell versus the Department of Social Services, because I think in order to go further into 1985 and 1986, considering that we did so much of 1983 today, we should talk about Monell versus the Department of Social Services, how that's relevant to a 1983 claim, to understand how you can incorporate it into a 1983 claim. And you might not be able to do this legally. This takes people years, people. Don't think that just because you're listening to me or you read this document or you start reading, it's going to take years. People, I'm not even good. I am so novice, it's ridiculous. But I've done a lot of reading, so I've become what's the word I'm looking for? I've become on the spot knowledgeable, if that's what it means. Like I pretty much can grasp something as soon as it happens, but I'm not legally proficient enough to break it down and even adequately put it on paper yet. But that's why we have online tools that allow us to paper things to write up what we want, so it works out. There's always a way to get what you want if your civil rights are violated, people. It's just going to take calm. It's going to take focus. It's going to take a lot of prayer if you happen to be someone that's religious, and it's going to take a belief in yourself and I would say your realization that your rights matter. On behalf of Operation Rock, people, I am tired, but keeping with my word, this was the second part to the video on how you can sue the prosecutors and the police. This discussed Section 1983, dove a little bit into Monell versus the Department of Social Services, and kind of walked you through the history, the elements, and the I would say details of a 1983 claim to more easily help you recognize this. So if you need to talk to an attorney about your rights being violated, You may be able to talk to him using some of the information, some of the theories, some of the definitions that I've put in this broadcast, and it'll help you gain the results that I didn't gain in the beginning. People, it's a hard journey, and it's not going to get any easier, but the only way it can end is if it begins. So you got to start taking the walk. On behalf of Justice and Operation Rock, thank you for watching, people. Have a great evening. God bless.